Good evening, everybody. Do you remember this story from last fall about a pet squirrel seized from an upstate New York couple by the Department of Environmental Conservation? It was then euthanized after biting an employee. That's how they determined if it had rabies or not. Well, now that couple is again suing, this time demanding $10 million from the state of New York in honor of Peanut and another raccoon named Fred. Now, owners of Peanut, Mark Longer and Daniela Bittner, accuse the DEC and the Department of Health of killing the animals without cause and say that the agencies didn't have the right to do so. The couple alleging that these actions were, quote, extreme and caused emotional and psychological distress as well as economic damages. Barry Covert is an attorney and partner at Lipsitz Green here in Buffalo, and he joins us live here tonight. Barry, before I ask you about the merits of this lawsuit, and it's Mark Longo and Daniela Bittner. First of all, what should we know about the case? I mean, it's a pretty lengthy complaint.
It's a lengthy complaint with a lot of different causes of action, a lot of different relief that they're looking for, but it's very unusual. It's very unique. It's suing over what New York State clearly considers to be wild animals. Both the squirrel and the raccoon are both wild animals under New York State's definition, under our statutes. Under our Constitution of the state of New York, all wild animals are actually the possession and ownership of the state of New York. So the state has the right, presumably, to engage in actions for their own property. So this is very unusual. I even saw an interview of their lawyer who admitted that they're really trying to get the courts to change the law here, or at least look at the law and reinterpret the law, because these are clearly wild animals under our law. They're not domesticated animals. They don't fall within the category such as a dog or a cat would. And they're now arguing that because we domesticated the squirrel and we were on our way to domesticating the raccoon, they should now be deemed domestic animals, even though they're not under the statute in the category that can be domesticated animals. So it's an argument that's going to be tough for them to sustain, but they're bringing it, and they're bringing it under a lot of different logical reasons: for theft of the animals, violation of the constitutional rights of the owners, just many ways to try to claim that somehow they were wronged here to try to get money from the state. And
seeking $10 million, which would essentially be taxpayer money. So is there any merit to this as you see it?
Under the current statute and the current case law, no. But they're trying to, they admit, or at least the lawyer does, that they're trying to get reinterpretations of prior cases, reinterpretations of the statutes. She makes the argument that, everybody has their interpretation of different things, and she specifically acknowledges that the domestic animal is going to be an issue, is going to be a problem, because squirrels and raccoons just simply are not under our law any more so than skunks or snakes or anything that is deemed a wild animal under New York state law. Just because you get the animal to perform some tricks, apparently, because you somehow get it under control, now makes it a domestic animal that you can now have in your house. It's a stretch of an argument, but
we'll see what happens.
We as lawyers make arguments.
That's right. Finally here, a lot of people are upset with how this case was handled. Some state officials have actually apologized with exactly how it was handled, but it's a big difference to go from that to the state violated the law here.
It appears to have been very heavy-handed, and if you believe what's in the complaint and some of the news reports I've read, it's unfortunate. It appears that New York State had the right to do this. The agents did get a search warrant from a judge who reviewed it, although the plaintiffs are claiming that not all the relevant information was in the search warrant, that the judge should have been given more information. But there was a search warrant, and there's a presumption when it comes to state agents that they've got a level of immunity from any of this. These are hard arguments, but that doesn't change the fact that it does appear to be very heavy-handed how this was handled here, that they were searching the house for 5 hours, apparently kept the owners of the house in the house for 5 hours, wouldn't let them have access to their phones, and euthanized the animals. I understand to check for rabies, but was there some method short of that? Did they explore it? They didn't seem to contact the owners before they euthanized the animals. So it does seem heavy-handed, but at the end of the day, you don't have the right to bring wild animals into your house.
That's what the law says. We'll continue to follow the case. Attorney Barry Covert, always great to see you, Barry. Thank you so much. Appreciate your time.